Are we live, Ms. Dean?
Yes.
Let's go on the record on cause number DC 204534. Council, make your appearances.
J. Edwin Martin for the plaintiff.
Andy Crone for defendants Rosewood Custom Builders LLC, Luke Dow, Carol Dow, and Chris Dow.
Connor Bateman for defendant Billy Lindemood.
This is Eric Scott, attorney for defendants Bobby and Tammy Lindemood and JR's Demolition.
Okay, let's go ahead and proceed.
Thank you, Your Honor. As I stated, I represent Rosewood Custom Builders and the individual principals, the Dows. That's Luke, Carol, and Chris. This is a pretty straightforward motion to dismiss pursuant to Rule 91A. In short, as the court is aware, this case involves an incident where Mr. Scott's client, one of the co-defendants, JR's Demolition, accidentally demolished a vacant house that was owned by one of the plaintiffs, Richard Avenue LLC. The plaintiffs have now amended their petition 5 times. Fairly recently, they added in individual defendant owners or principals or managers of my client as well as JR's. In short, the argument is that the Dows are afforded corporate protections under Texas law. If this is an insurance issue, Your Honor, Rosewood is sufficiently insured for this type of claim. The court may recall that there was some previous discussion about coverage issues with JR's. That's not the case as far as my client. Simply put, there's no legal or factual basis here to hold the Dows personally liable. So even if we take the plaintiff's allegations that the Dows somehow caused this house to be demolished, again, they have the corporate protection of the LLC. So there's no basis that the Dows as principals of Rosewood could be liable. So as such, we're asking for dismissal pursuant to 91A. And the alternative, if the court believes the proper avenue for that is a motion for summary judgment, we'll obviously defer to the court's judgment and pursue that, but we think the outcome would be the same and it would just end up wasting everyone's time and money. And finally, we're asking for attorney's fees, which are of course discretionary now. If the court grants in whole or in part the Dows and Rosewood's motion to dismiss.
Response?
Yes, Your Honor, this has been mischaracterized as a piercing corporate veil or alter ego case. It is not. We have a direct cause of action for negligence, gross negligence, negligence per se, and gross negligence per se against these 3 defendants. We have listed not less than 10 things that they did or did not do that constitute negligence. For example, the way I would analyze this or analogize it is, these are the captains of the Titanic. These are the captains of the Exxon Valdez. And you can't sit there and say, well, it was Exxon's boat, so the captain's not liable. Under traditional, longstanding Texas tort law, if you commit a tort, regardless of whether you're a corporate agent, you are individually liable. If you're a drunk driver and you're driving a truck, the trucking company is liable, but so is the truck driver.
So let's just kind of break this down. So these individual defendants, were they, and I get the analogy to the truck driver kind of, but were these people at all involved directly with this demolition, or were they just corporate officers?
They were the ones who were saying which house to demolish.
No, Your Honor, they're the people that run the company. And we've made this argument as a separate argument, but I think it'll answer the court's question. We've previously argued in a pending motion for summary judgment that Rosewood had absolutely nothing to do with the demolition. The reality of how this happened is that very simply, JR's made a mistake, screwed up, went to the wrong house and demolished it. JR's and its employees. Rosewood didn't direct them to the wrong house. None of the Dows sent them incorrect instructions. The Dows run the company. They're not, they had nothing to do with the demolition. They had nothing to do with how JR's wound up at the wrong house. I think that is what you're asking, Your Honor.
I guess what I'm trying to figure out is, usually let's say that, a Walmart, a truck for Walmart gets in an accident, you can't sue the CEO of Walmart as a defendant. You can sue the truck driver usually. The first kind of step in the analysis is, did these people have anything directly to do with this particular transaction, I guess, or was there somebody else who was involved with it? And I get your argument. I thought I had denied the motion for summary judgment. I'm not granting a motion for summary judgment as to Rosewood. But you said there's an order. You said I haven't signed the order.
Well, and I wasn't suggesting or trying to shift to re-argue that. I was just pointing out that when we had that hearing, we discussed this. And I just to answer you, what you did at that time was ordered the parties to mediate and ordered additional discoveries and stated that you wouldn't be ruling on that motion at that time.
Okay. Do I need to rule on that? Is that mediation already occurred now?
It has.
Yeah. So I'm going to deny the summary judgment as to Rosewood. So I understand your position is you're trying to, kind of argue that the demolition company was solely at fault. Who is involved with getting the demolition company to go out there? Who is the individual who did that?
That's the thing, Your Honor, and why I feel like, respectfully, Mr. Martin's analysis is misguided. Is nobody from Rosewood got anybody to go out there. They just owned a different house. They had done some paperwork with JR's, and JR's and its employees did this. So when you say go out there, nobody from Rosewood had anything to do with that. They signed, I believe it's Chris Dow. I'll have to check. Signed some paperwork for a completely separate transaction. And
Rosewood hired the demolition company, correct?
Correct. Rosewood owned a different house, wasn't even next door, anything like that. They dealt with the city and got some permits.
So who with Rosewood was involved with that transaction? Who is the individual?
I don't have that in front of me. I believe it was one of the three Dows, Chris Dow, but again, I'd have to supplement the briefing on that. I don't know that off the top of my head.
I guess go ahead.
That's my point. Under Rule 91, you have to take the allegations as true. We have said these are the three managers of Rosewood. JR's was following the instructions of Rosewood as to which house to demolish. I'll give you a very simple example of what the Dallas could have done to stop this from happening. Under the Dallas Building Code, you're required to put a 3.5 by 5 foot construction sign on your construction site. If they had put that sign out in front of the yard and told JR's, do not demolish the house unless you see the Rosewood sign, then A, they would have complied with the building code, and B, the house would have been torn down.
Your Honor, that we addressed this during the last hearing or in briefing. That's just completely inaccurate. That Mr. Marr is misapplying a rule about a sign that doesn't even apply in this instance. We've addressed that in depth in our pleadings. The bottom line here is he talks about these 10 things they could have done. And maybe we need to hear from Mr. Scott about who talked to anybody at his client, but these are not any legal standards. Mr. Martin has made up 10 things that he's made up some non-legal duty that he believes these individual defendants could have or should have done. He's misinterpreting local ordinances like the sign, which we've already, rebuked in writing. It's not accurate what he's saying. So there's no legal basis for holding the Dallas liable, and making up 10 things they could or could not have done is just not based in fact or law. They're just things Mr. Martin made up.
Your Honor, those are duties of a person to not demolish somebody's house. Another example would be they could meet them at the property and say, yes, this is the house they're supposed to demolish. They could have met beforehand. They could have used GPS coordinates to make sure that they're at the right house before they gave the green light to demolish it.
Your Honor, again, Mr. Martin's imposing absurd duties that are not written anywhere. And the reality is, and the evidence shows that my clients gave Mr. Martin's clients the correct address with a photograph of the correct house, and they just messed up. And to impose any duty in hindsight because a third party messed up on what somebody could have done, you could just as easily make up some duty for the plaintiffs the investors who lived in California, I could say, well, it wouldn't have been demolished if you had been standing in the front yard all the time. That's of course absurd, just as what Mr. Martin's suggesting is absurd.
Your Honor, I'm not making up the tort duty to not demolish somebody's house.
And again, this is the problem with this case, is that it's being grossly mischaracterized, because Rosewood did not demolish anything. It simply owned another house. And to hold its principals liable when it has $1 million of insurance, which far exceeds the value of this claim, there's just no legal or factual basis, which I suspect is why Mr. Martin keeps just repeating the same thing: legal duty not to demolish a house. Well, Rosewood didn't demolish anything.
Your Honor, under Rule 91A, you have to take the allegations taken as true. My allegations are these three people are the managers. They were responsible for designating which house to demolish. They failed to meet the duty in that regard. And I listed very specifically 10 different ways that they failed to meet the standard of care.
And I would briefly respond that case law shows, and I'm quoting, threadbare recitals of the elements of a cause of action supported by merely conclusory statements do not suffice. That is exactly what we have here.
Your Honor, my petition is 47 pages long. I have 3 pages that address the 10 things that they failed to do.
And again, those 10 things are things that Mr. Martin has just made up. They're things he believes my client should have done. They're not any standards, or they're not any case you'll find. They're just 10 things Mr. Martin made up and listed.
They are things that a prudent builder would do to prevent the wrong house from being demolished.
And I would say, again, that's a mischaracterization in this context. Although Rosewood is in the custom home building business, in this case, they are not a builder. They are merely a property owner and the owner of a different property. That is what they are in reality in this instance, which is also why the 3.5-foot sign ordinance doesn't apply, because they're not a contractor. In this case, they're not even a builder. They're a property owner and nothing more.
Your Honor, these are jury arguments. These are not.
Yeah, I mean, what I guess I'm kind of struggling with here is that, you know, there's two categories of folks here. There for defendant Rosewood. There would be those who, if for example, if the Dows had nothing to do with the individuals, had nothing to do with this transaction, nothing to do with hiring this individual, they're just simply corporate officers, I would tend to think you need to pierce the corporate veil. There's no evidence of that. There's no pleading of that, and that would insulate them from liability. It sounds like the argument is that they did some kind of direct negligence, kind of like a truck driver or a vice principal would, you know, a salesman who makes a negligent misrepresentation. I feel like there's a little bit of hide the ball from the judge. You know, I've asked you who that person was. I think probably the most appropriate way to handle this is through summary judgment, since he is right that I have to take the pleadings as true. So at this point, I guess I'll deny the 91A motion. I'm not going to award attorney's fees to anyone. And then, you know, there needs to be some kind of discovery on who exactly made the decision to hire this company and do the things they did. They're probably at least one of these three people was involved in this, it sounds like, but I don't know that for sure. So, and it looks like there's a summary judgment set for next week or this week on Friday. Does that cover the same issue?
No, that's, Your Honor, that's a partial summary judgment solely focused on methodology for calculating damages. It's nothing to do with liability.
Okay. Anything else, guys? Did you submit an order on this?
Your Honor, I did not, but I will.
Okay. Go ahead and send that to opposing counsel and e-file it and email my court coordinator.
Okay.
And when you do the order, could you include on it that it says on March 8th, 2021, this matter came on to be heard at the beginning, as opposed to just put on this date, because it just helps with the filing of this stuff. Does that make sense? So just include in the order what day the hearing was. But try to get that to me. It'd be great to have it today, but if not, to get it to me before Friday.
I'll get to that.
All right. Anything else, guys?
No, Your Honor.
All right. Thank you, guys.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Okay. We have anyone here on the call? Mr. Triplett, what are you here for? And Mr. Garza?
Good morning, Your Honor. I am here for a hearing in front of you, I believe, in 30 minutes with Reagan Herod. I just got on early because I had a bad connection and wanted to make sure I was able to connect.
What's the name of the case?
Haltom or Triplett versus Haltom. It's a motion to remove
Oh,
Liz Bennett.
that's just so you know, that's not set for another hour and 10 minutes. So
Oh, okay. I didn't realize that. Okay. He had told me in 30 minutes, so I apologize.
that's okay. And then Mr. Garza, what are you here for?
I'm here for DC 20-06183. It was an intent to dismiss reset from January.
Okay, so this is the DWAP docket. Okay, which case again is that?
Sure.
What was the name of the case?
Ibarra versus Rodriguez.
Yeah, okay. So tell me what's going on with that one.
We're just waiting on an order to be signed on our motion for subservice.
All right, let me take a look at that. When did you say the subservice? Oh, it's okay. Let me see it. There we go. You have.
I'm sorry, I didn't catch that.
No. So I guess just a quick look at this. There's an issue about. Do you have confirmation that that address is the correct address?
I believe it'd be in our motion, Judge.
All right, do you have the motion in front of you?
I'm pulling it up.
Let's see.
So I guess the address that we have for her was provided to us by her dad. Her dad's the plaintiff, and so he's the one that's been giving us updates on her whereabouts, along with our process servers who've been running, skip traces to find her.
Let me just look it up real quick. Okay, so I'm looking at this, the declaration.
Right. So they list the 831 nursery address as a good address for her.
But then the process server says that there's no apartment number, so we can't find her. And then for the 520 Greenleaf address, the occupant didn't know her. Let me just see. I just don't, there's a lot of stuff here. I just don't see any proof that we know that that's the right address, that second address. Do you see something in the, maybe we missed it somewhere in the motion?
I mean, Judge, I'm just going off the process server's declaration.
And which exhibit number are you talking about?
That would be Exhibit A.
It says, the process server doesn't say that
I'm
though.
sorry. Give me a second.
It says on Tuesday, May 5th, 2020 at 2:30 p.m. at 831 Nursery, Irving, Dallas County, Texas, 75060. There was no provided apartment number for defendant. The office is closed until further notice. I placed a call to Brenda, manager at these Brentwood Apartments. She verified the defendant moved with no forwarding in September of 2018.
I'm sorry, Judge. Exhibit C is the most recent, would be the most recent. And that would have the 520 Greenleaf Drive in Mesquite address.
And but nothing in there verifies that that's the correct address either. Who's the defendant? Her name is Vanessa Rodriguez.
Yes, sir.
The only confirmation is someone named Noel Ariano lives there. Unless I'm missing something. Do you see confirmation? I mean, I'm not super strict either. I just need to, is there a something, is there
The 520 Greenleaf address was given to us by her dad. And so that's when the process servers went out to.
Yeah, but no one, okay. That's not in the affidavit though, is it?
No.
I mean, trust me, I would like to be able to decide this. It makes these goes quicker, but I just don't see any proof that we know that this is the correct address. And it can be simply as simple as, hey, there's a car parked out front and it's registered to her, or there's a DCAD listing, or there's, that she owns a piece of property or whatever, or look at the mail and somebody from there's a piece of mail that's, addressed to her, or, I saw the package on the porch and it's direct, there's a million ways to do this. I just don't see that it's been done here. All right, well, let me do this. We'll go ahead and reset this 30 days and you guys can try to get a new subservice. How does that sound?
That's fair.
All right. Thank you. You have a good day, okay?
Thank you guys. Appreciate it.
Thank you. Oh, I didn't sign it, so I would say. Okay. All righty. Thank you, Rhonda. Is everyone here on this? I guess it's still a little early. Hello, Michelle Garris, Mr. Reamer.
Your Honor.
Anyone here on any cases besides the Hume case? Anyone here on the Sanchez case or the Vasquez case? Ms. Sanchez, are you here? Are you Juana Sanchez? Are you with your attorney? Sanchez, you can unmute. It's okay. Go ahead and unmute. Ms. Sanchez, can you hear me okay? Can everyone hear me okay? Mr. Reamer, can you hear me? Ms. Sanchez, do you want to unmute? Are you there with your attorney?
Oh, yes, I'm here. I don't have an attorney.
You don't?
No, my daughter is gonna help me.
Oh, I have down that your attorney is Marcela Alvarez Parra. Is that not your attorney?
No, she left my case.
Okay. All right, well, that may make it a little more difficult, but we'll see. Ma'am, did you file a motion that goes along with this order requesting a receiver?
Yes, I filed the motion
When did you file that, ma'am?
on January. I think it was January 26th. I went to the court and I bring the paper with the motion.
Let me see. All right, there's a bunch more people here.
Okay.
All right, is anyone else here on the Sanchez case? Okay, is anyone here on the Vasquez versus Ortiz case?
Counsel for plaintiff, Andrew Birdsell for Melanie Vasquez.
Maria Vasquez or Melanie?
Well, Maria was the mother. Melanie has recently reached the age of majority. I apologize. So we probably should I need to do a suggestion
Okay.
majority.
And is opposing counsel here?
Not sure just yet. There's one opposing counsel.
Mr. Perez, Damian Perez?
Let me press. Yes.
All right. It's 10 o'clock. When do you want to reset? When do you want to set your case for trial?
Well, we just recently started doing discovery. We had a little bit of service issues between the two parties. So we have only just began discovery. So summer or fall would be great for us.
I was kind of looking through my docket on, this has been a weird year with COVID and no trials and stuff like that. A date I noticed that we just don't, a lot of cases have settled, so it's pretty open for that particular day is November 30th. Would that give you enough time to kind of get everything taken care of?
I believe so. November 30th would be fine with plaintiff.
Okay. That's a relatively open date at this point. So,
I can send that on to defense counsel.
okay. So what we're going to do is go ahead and set it for trial on November 30th. And then we're going to, and then if you guys want to do an agreed scheduling order, you can.
That sounds perfect.
All right, Ms. Sanchez, I'm going to take care of this other matter and then I'm going to talk to you, okay? So you'll just have to
Yes.
wait for this to be over, okay?
Yes.
May I be excused?
You may be. Good to see you, Mr. Bertzel.
Thank you.
All right, we have a status conference on the Hume versus Global, 5-Star Global case. I think I just saw in my emails that somebody wants to withdraw, but I wasn't sure who.
Yes, Your Honor. I don't see before we get started, I don't see Miss Pettit on Zoom.
I am. Thank you, Ms. Shigaris. I'm here, but just by phone. My internet was being slow this morning, so I thought making sure I could appear by phone was better than a chopping out internet speed. So I'm here just by phone.
Okay. So who is the attorney that wants to withdraw?
Your Honor, we have 3 things to talk about this morning, but obviously the withdrawal being one of them. So both my firm as well as Ms. Lopez, who was our lead counsel, her firm have filed a motion to withdraw. Since the filing, our clients have retained new counsel, and in fact, Israel Silvas is here as well as his associate Cliff Riley, and they have filed a notice of appearance on Friday on behalf of all the same entities. And so that's why we presented the unopposed motion to withdraw and substitute them in as counsel. So the plan would be for me to handle the issues today at the status conference to get those items wrapped up. And then hopefully Your Honor will sign that order. So after today, Mr. Silva and Mr. Silvas and Mr. Riley will take over.
Okay. Sounds good. Well, sorry to see you leave the case. Let's see. Okay. Okay, well, let's go ahead and take care of that. So the order, anybody opposing this order to withdraw?
No, Your Honor.
No, Your Honor.
No, Your Honor.
All right, I guess I will go ahead and sign that at the end of this hearing so that we can at least move forward with this. Okay, what you said there were 3 issues, Ms. Shigaris?
Yes, well, now there's only 2 remaining. We took care of the first one, so I appreciate that. The next issue, Your Honor, relates to the home party production.
Okay.
If you'll recall, Ms. Pettit and I worked for a series of months to try to reach agreement on competing motions to compel, which resulted in first a Rule 11 agreement by which Ms. Pettit's clients were supposed to supplement discovery back in January. And then if you recall, Your Honor, you signed an order requiring them to supplement other discovery answers as well as their production no later than February 15th. Unfortunately, Ms. Pettit's clients did not meet either of those deadlines. I've continued to try to reach agreements with Ms. Pettit because we do not want to have to file a motion for contempt or sanctions But at this point, it's a little unclear of whether or not they produce everything. On Friday, about 20 days after the deadline in your Honor's order, we received 30,000 pages of production. So I don't know if Ms. Pettit's clients are done with their production. So what we hoped to accomplish was avoid the need for a motion for sanctions for failing to comply with the order and just find out when we're going to get all the documents. We've already had to push out the mediation, depositions, and we just want to get the documents so the case can continue to move forward.
May I respond, Your Honor?
Sure.
So, as Your Honor, I'm sure as well know, the ice storm hit right when all of this was due. Our vendor is based in Austin, and they were without electricity. Our client was stuck in Louisiana without electricity or the ability to get back. Excuse me. So we ran into obviously some timing issues based on the vendor and all of that. As of I think it was the 22nd, so about a week after that, everything that's new that opposing did not already have in their possession had been produced. So they have everything in their possession now that they did not already have in their possession. And as Your Honor recalls, it's contention in this case that they wrongfully accessed and utilized my client's email accounts and in a situation where they didn't own them, but they went ahead and took all of them, including the privileged emails with me. Anything that is not part of that bucket, so we'll call that bucket the stuff that they already have access to and have gone through and have presented to Your Honor times during hearings. That bucket aside, everything new, since my clients have not, the date moving forward from which they have access to everything that's responsive has been produced to them. So they have all of that. There are still items which they already have that we're in the process of sifting through, but there's nothing new that they do not already have in their possession. We do need to get them an updated privilege log in regard to some of that, but there's nothing that we have in possession that they don't have other than things that'll be on a privilege log. So obviously it's a huge body of documents. I'm not saying counsel did this, but the clients, it's our contention, took and accessed and converted years and years and years and years of emails that don't belong to them. I know Mr. Garris and her team dispute that. But those are the remaining documents. We're still in the process of going through the years and years and years of production, and we'll finish that. But all the new stuff they have in their possession that we've given to them.
Okay. I only caught probably 3 of every 4 words there, but Ms. Shigaris, does that answer your question, or is yours?
A little bit. I think, as I understood it, anything that they claim we don't otherwise have access to, they've produced. So that's helpful to know now. My concern, Your Honor, is there is some disagreement as to what we have access to, because if you remember, her client was fired. And so when he was terminated, his company emails resided on our server, and we terminated access to his company emails. So there is some disagreement about who should have access to that. But putting that aside, I don't want to guess whether we have access to them or Ms. Pettit has access to them. I just want the full production. And so in order to schedule depositions and mediation, we need to know when that's going to happen, because Your Honor ordered it to happen by February 15th. And so if Ms. Pettit could just give us a date certain when the rest of her production will be provided, that's all we need.
Okay, Ms. Pettit?
We are working diligently, Your Honor. I have multiple lawyers working around the clock. This is a massive, massive amount of documents. Like I said, these are documents, and I'm telling the court, these are documents that they have in their production on their server that they have gone through. Nevertheless, we are doing everything we can to get through this massive amount of documents. I would, like I said, they have them all. This entire exercise has been an insanely expensive and burdensome task on my side, given the fact that opposing counsel has these documents. But that said, I know that's a rant, so I apologize for that. I would say that we're doing a rolling production. That's why they got 30,000 documents on Friday that they already had, but we produced 30,000 more documents. I think as we're continuing to do a rolling production, I think we can get everything done in the next 2 weeks at the latest. I'm aiming for sooner than that, but that's just the reality. Like I said, we've got full-time people on it working around the clock.
What date did you say? What day did you say?
I would say, yeah, we're doing a rolling production. I don't see any reason why we can't get it done in the next 2 weeks. But I can assure your honor, just like I've assured opposing counsel, we're doing everything we can to get them these documents. If they want them sooner, they have them. They can search them in their own records, but we are doing everything we can to get them duplicate copies of what they already have.
So, I don't think we ever officially went on the record, so this is probably something we should put on the record. Let's go on the record on cause number DC 208643, Hume versus 5-Star Global. Counsel, make your appearances.
Julie Pettit on behalf of the plaintiff.
Ben Reamer here on behalf of Michael Nall and Mid Marketplace PBC LLC.
Sarah Krajewski on behalf of defendant Southfield.
And Your Honor, my colleague, Sydney Shimkus, I'll let her make an appearance. She's going to be assisting on behalf of Mr. Nall and Mid Marketplace moving forward.
Good morning, Your Honor.
Good morning.
Kevin Buchanan, Court Appointed Receiver. Excuse me.
Good morning,
Mr.
everybody. This is my first introduction here to the proceedings that have been going on. This is Israel Silvas, and I'm here with my law partner because he got promotion last year. So I'm here with my law partner, Cliff Riley, on behalf of.
And who's your law partner?
Cliff Riley, Mr. Cliff
Riley. Okay.
Good morning, Your Honor.
Ms. Shigaris, I think you kind of dropped off and we went on the record. So go ahead and state your name.
Leslie Shigaris on behalf of the FSG parties. Sorry about that, Your Honor. Can you hear me okay now?
Yeah, we can hear you fine. So I just wanted to go on the record. The Ms. Pettit it kind of explained because of, I guess, the ice storm and everything that was going on that there was a difficulty in production, and she also made some comments about how you guys already have these documents, et cetera, et cetera. But she did say that she could get this document production finished within the next 2 weeks. Is that correct?
Yes, Your Honor. Hopefully sooner. We'll do everything we can.
Okay. And I guess if there needs to be further motion practice about that, we can, but her representation is that within 2 weeks. Ms. Shigaris, what are your thoughts on that?
That works great for us, Your Honor, and hopefully we don't have to have further motion practice.
Okay. All right. You said there was a third thing, Ms. Shigaris?
Yes, a little related to this. If you remember back in November, related to the issue that we were just discussing as to who has access to Ms. Pettit's email accounts that reside on the company servers that were their company emails. And back in November, we said we had no problem exporting Mr. Holmes' email boxes in full using a third-party vendor and providing that to Ms. Pettit for her and her client to have access to and review, but that Ms. Pettit's client needed to pay the cost to the third party associated with that work, since that's not something that would be done in-house. Ms. Pettit, we talked about that at the hearing in November. Immediately thereafter, we put Ms. Pettit directly in contact with Roland Technologies, the third-party vendor, and she confirmed in writing, understanding that they would be responsible for the cost and emailed directly with them. Unfortunately, as I understand it from talking to Ms. Pettit, her client has instructed her not to take possession of those files for whatever reason, and it's not really pertinent necessarily to the issue today, but because of that, they have not paid the vendor. And it's about a $700 invoice that the vendor is now looking to our client. And we just want to make sure that they get paid since they did the work based on the representations.
Ms. Shigaris, I don't mean to cut you off, but I want to let you know it's been paid. So I don't think that's an issue. It's been paid.
Perfect. Then I hadn't been updated that from you, but if it's been paid, then that resolves that issue.
Your Honor,
Sounds
if I
good.
may, there's only one additional small issue. I wanted to let you know that as you recall, there was an appeal up to the Dallas Court of Appeals in regard to whether or not the bond that was paid by my client prevented or allowed the receiver to continue to move forward or not. And the Court of Appeals has since affirmed Your Honor's ruling and indicated that the receiver may move forward. And so I don't know what needs to be done in regard to the new counsel that's coming on board and things of that nature, but I want to be sure that Mr. Buchanan has everything he needs so that he can proceed at Your Honor's previous direction.
Mr. Buchanan?
I've got everything I need. I know what to do, Your Honor.
Oh, perfect.
Great.
Looking forward.
Anything else we need to chat about? When is the trial setting on this case?
It's in November.
November, yeah.
I think, but I can't remember the date certain. And unfortunately, I stepped outside to get better reception, so I don't have my calendar in front of me.
Okay. So nothing soon.
No, Your Honor.
Well, I urge everyone to read the new Supreme Court order that just came out last Thursday or Friday. I think it's going to change things eventually here in Dallas County. So I think it does increase the chances that the trial will go forward in November, assuming the pandemic continues to go in the direction I hope it appears, and I hope that it currently is. So anyway, anything else we need to chat about before I let you guys go?
Your Honor, just
Not from plaintiff, Your Honor.
quick scheduling issue so that it's clear from what Ms. Shigaris was saying about the scheduling of depositions and mediation and so forth. We are proceeding, Ms. Shimkus and I are proceeding with our mediation tomorrow on behalf of our clients as previously scheduled. So I just want to make that clear that mediation is taking place tomorrow.
Great. That could potentially, but I don't remember. Are you guys each mediating these separately? Is that the idea, not doing it all at once?
Initially, there was a global mediation scheduled for tomorrow, but as Ms. Shigaris said, there have been issues with document production and scheduling depositions and so forth that necessitated the postponement of that with respect to Ms. Shigaris's client and Ms. Pettit now, Mr. Silvas's client. I'm sorry, I'm getting all these parties confused. The home parties and the FSG parties are not mediating tomorrow, but the null parties and the FSG parties will proceed tomorrow.
Well, I hope it works out, Mr. Reamer and Ms. Shimkus and all of the counsel that are involved in that. Who's your mediator?
Judge Ashworth.
Okay. Well, good luck. He's a good mediator. Anything else we need to chat about?
Your Honor, just a very quick status update as well. So as the court call, Mr. Riley and I have also been representing former CEO of 5-Star Global, Mr. Ed Delgado. We will continue with that representation. There's a couple of things that I wanted to point out about. I know we weren't scheduled to discuss that case today, but it might be relevant to a certain extent. The first one is Ms. Pettit has been producing documents without differentiating whether or not they're respective to the Delgado case, the Null case, or the 5-Star Global case. Those are three very different cases, which obviously we want some clarity on that. But more importantly, the Delgado case is on a more expedited timeline. I believe our discovery deadline is in May. And there are, still, we had a mediation that was scheduled for tomorrow, which was unilaterally canceled at the last minute. So we want to make sure that we comply with any deadline set forth by the court. And then we also want to make sure that all of our depositions done before that May date. We believe we should be ready to do that, especially now that we've received Pettit's production. But, we just kind of highlight that Delgado case is moving forward full ahead based on the court's previously issued scheduling orders. So aside from that, I'm just letting the court know that we are still diligently prosecuting that matter.
Okay, Ms. Pettit.
I have nothing to add to that. That's true.
Okay. All righty. Well, good. You guys have a great day. Ms. Shigaris, sad to see you go from this case. We always enjoy working with you and your firm, and we'll, I'm sure, see you on the next one, okay?
Yes, thank you so much, Your Honor. Appreciate your help on this.
Yeah, and I just signed the order of withdrawal, so you guys be safe.
All right, thank you, Your Honor.
Thank you.
Bye-bye.
Your Honor.
Thank you, Your Honor.
You.
Thank you.
All right, Ms. Sanchez.
Yes.
Give me 1 second, okay? I'm gonna put you on mute.